Parker and Winwood were both having a big night at a bar in New Zealand. They ended up, as the judgment says, tossing for money, which I'm pretty sure is a polite way of saying they were playing two up. At the end of the game, Parker claimed that Winwood owed him £5, not an inconsiderable sum back in those days. He demanded the money and Winwood refused and left the bar. Parker followed him, got on the same tram, and the two rode the tram all the way out to the terminus. I guess Winwood was hoping that sooner or later Parker would get sick of it and get off the tram. At the terminus there was a fight and Parker seems to have gotten the better of it. Winwood's evidence was that Parker then said, "If you do not give me that fiver, you bastard, I will cut your throat." Winwood says that he still refused and that through the use of physical force, Parker then reached into his pockets and took £10, 9 shillings from his pocket. Parker says that in fact after the fight Winwood reached into his pocket and voluntarily gave Parker the money. The jury seems to have generally believed Winwood, but on the question of how Parker got the money, they believed Parker. In other words, they believed that Winwood had handed the money over. The key question which came before the Court of Appeal was whether it could be theft if Winwood had handed the money over. The court found that it was still theft. Their Honours said the evidence consists chiefly of the statements of two men, both under the influence of intoxicants at the time of the occurrence. The assault was denied by the accused, but it was proved by independent evidence. The accused said that the money was handed over to him by Winwood. If that is so, it was done so immediately after the assault as to make it highly improbable that it was done voluntarily. So even though the money was handed over, it was handed over under threat, and the conduct was still theft.